We got a fast-moving and breaking story about those SNAP anti-hunger payments that go to 1 in 8 Americans, and Donald Trump and the Trump and MAGA administration's resistance and punishing of hungry people and poor people in America. Yes, the shutdown may be over, but that's going to take several days. In the meantime, there is a hot and heavy pursuit of those funds to make sure that people don't suffer, being led by the Democrats in the courts. We've got a ruling by the First Circuit. We've got a ruling by Judge Talwani in Massachusetts. We've got a request to the United States Supreme Court, all on this one day, as people who care about other Americans fight to get them the remaining $3 billion in funds, as Donald Trump tries to claw back the $5 billion that his administration paid out, so that when people open their refrigerator, there's food to eat, and they're not living under the world of food insecurity. And this was all set in motion, I suggest, by a supremely smart and crafty decision by Ketanji Brown Jackson 2 days ago to stay temporarily for 48 hours a decision by a federal judge in Rhode Island, Judge McConnell. That's the first domino. But she stayed it. People were like, oh, I don't want Ketanji Brown Jackson to stay it on the payment of the last $3 billion of SNAP anti-hunger payments and food stamps. Let it be another justice. No, she was smart, because now she set up the trap, political and legal trap, for Donald Trump, and he stepped right in it. Now he's forced to go today on an emergency filing and ask the United States Supreme Court for permission to let Americans starve. That's pretty crafty, as she already maneuvered so that $5 billion out of the $8 billion was already paid. It's not enough, but at least that payment went out. And now Donald Trump and his legal case is set up for failure in a way because of Ketanji Brown Jackson. Let me tie together the First Circuit ruling, Judge Talwani's ruling in Massachusetts, the original ruling by Judge McConnell in Rhode Island, and the request at the United States Supreme Court, weaving it together on the MeidasTouch network. I'm Michael Popok, and for Legal AF. All right, let's get into it. A week ago, Thursday, Judge McConnell in Rhode Island ordered that as much of the $8 billion that was owed in November to people who are recipients of this entitlement, that they're entitled to have the dignity of food security, get paid. And if the Trump administration wasn't going to make the full $8 billion in payments, he wanted to know why and how, and make sure it's not arbitrary and capricious. Well, after it got back in front of him, and the Trump administration said last Monday and Tuesday, well, we're not, if we make a partial payment, it'll be weeks or months. He said, no, it'll be hours. I'll see you back in my court on Thursday. He brought everybody back on Thursday, and he issued a new ruling enforcing his original temporary restraining order, in which he declared they are to make the full $8 billion in payments and get it from other funding that they had available to them, including a large fund we call the Section 32 funds, devoted for child nutrition, that was overfunded, had $23 billion in it. Take $3 billion out, top up the $8 billion that's required to make the full payments of $350 per family, and make the payments. 1 in 8 Americans are below the poverty line and get SNAP payments. 1 in 8, 16 million children. That's what we're talking about. And it's time to do it. That was his ruling on Thursday. Did the Trump administration make the payment? Sort of. They made 5 out of $8 billion and then complained about the rest. They ran to Judge McConnell and asked him for a stay of his order on the remaining 3. He said no. They ran to the First Circuit Court of Appeals and asked for an administrative stay in time for them to make an appeal. They said no. They ran to the United States Supreme Court over the weekend and asked the justice there, which would be Ketanji Brown Jackson for the First Circuit, to grant a temporary administrative stay so they could file their full stay request at the First Circuit. She said yes. People went crazy. But they shouldn't have. If you read carefully the request by Trump and knowing that they had already paid the $5 billion out, the request was not for an emergency shadow docket appeal. The request was for a temporary stay to give the First Circuit time to make their ruling on a full briefing. So Justice Ketanji Brown Jackson She gave a very short stay. It was about 46 hours. Why? Because then, if Trump were to lose at the First Circuit, which he has, and she knew he was going to, and I'll tell you why when I read from the decision in a second, then he'd have to go back to the full Supreme Court and beg them to let him starve poor Americans. Think about the optics. Think about it legally. And she also knew that from a record standpoint, he had developed a terrible record undermining his argument, Trump, because he'd already paid the 5 out of the 8 billion out. So he couldn't claim on an emergency docket that he needed an emergency appeal for the last 3 billion. That made no sense. So that she liked. And that's why Trump over the weekend tried to claw back the 5 million to make his record better, but too late. Outmaneuvered by Justice Ketanji Brown Jackson. And now he has to suffer through the politics as he continues to shift and flip-flop his position all weekend, as he's doing with the government shutdown. She also wanted to take advantage of his tendency to flip-flop.
Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popok's new law firm. It's called the Popok Firm. Michael Popok's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas Mighty and legal AFers who were approaching Michael Popok with their cases and saying, can you help us? And at that time, Popok was not able to. So he went out on his own. He started the Popok Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popok's firm is free. Give him a call. See if you have a case. It's thepopokfirm.com, thepopokfirm.com, or you can call 877-POPOK-AF, P-O-P-O-K-A-F. So 1-877-POPOK-AF. Give Michael Popok a call. And I'm really proud of you, Popok. Thanks for all the hard work you're putting in.
Now we've got the decision by the First Circuit. Let me bring you there. First Circuit says, late yesterday, that they're not going to grant the stay through the duration of the appeal because he's likely to lose on appeal. That there was no abuse of discretion by the judge, that they'd already issued 5 out of 8 billion. There was plenty of funds to make the remaining, and she was not going to rule in their favor. Here's what the Judge Rickleman, who is there were 2 Biden appointees and 1 Obama appointee on the panel. Rickleman's very interesting because she used to work for the Center for Reproductive Rights arguing for abortion rights. That was her day job before she became a judge. She wrote the majority 3-0 opinion. Here's what she wrote on page 4. 42 million people, 1 out of every 8 Americans, use monthly benefits from the federal SNAP program to buy food for themselves and their families. She also put it in sharp relief when she said about the program itself. She said on page 5, for low-income Americans, SNAP is a vital bulwark against hunger and food insecurity. Access to food is, of course, a basic human need. Further, food security is a critical factor in health and well-being, the ability to stay in stable housing, and children's physical and educational development. Without SNAP, tens of millions would go hungry, the first among a cascade of other health and financial harms that would befall those forced to go without enough food, particularly in the months leading up to winter. And that's why she, along with the 2 others, refused to block the order of Judge McConnell enforcing his original temporary restraining order that the next $3 billion get paid out. Now, there was a second case up with Judge Talwani that was filed at or around the same time by 23 attorneys general, led by the Attorneys General of Massachusetts and Rob Bonta, the Attorney General of California. I have an interview of Rob Bonta that I'm doing that will be up tomorrow morning on Legal AF YouTube about these issues. In their brief, they asked Judge Talwani, who was sitting on a little bit on the sidelines waiting to have another request for temporary restraining order. They filed a second request for temporary restraining order just in the last few hours. They filed it also on the 9th when the First Circuit ruled. Plaintiffs further motion for a temporary restraining order. I'll post this on Legal AF Substack. Here's what they say there. Plaintiffs, which are the 23 states, blue states, come to this court again for the third time in 13 days to seek emergency relief from yet another unlawful and senseless act by the U.S. Department of Agriculture and other defendants in their funding and oversight of SNAP. We respectfully request an emergency virtual hearing on Monday because of the irreparable harm and all of that. Judge Talwani has issued her ruling. Here's her ruling that came out just today on the 10th. Judge Indira Talwani, electronic order granting in part plaintiff's further motion for temporary restraining order. Good cause shown, the USDA memorandum issued on Saturday, November 8th, directing that to the extent states sent full SNAP payment files for November 2025, they must immediately undo any steps taken to issue full benefits and shall advise the appropriate offices of those steps is stayed pending further court order. And then she set the hearing for the 13th at 3:30, meaning over the weekend, the Trump administration tried to claw back the money, the $5 billion they'd already paid. She has stopped that on her watch while she gets to her full hearing on the 13th. So you have Judge Talwani stopping the clawback until she gets the hearing in about 3 days. You've got the First Circuit who's ruled, and now we're on a 48-hour clock of Judge Ketanji Brown Jackson, the Supreme Court justice, is making, because she said 48 hours after the First Department ruled, she would lift her stay, giving the parties time to run back to court to ask for some sort of emergency relief. And now we've got, just now, in the last hour or so, we've got the request by letter by John Sauer, Donald Trump's Solicitor General, former his personal U.S. Personal appellate criminal defense lawyer, writing to the clerk of the court. It says, pursuant to the court, this letter confirms that the government will file a supplemental brief by 4 p.m. this afternoon. And there's been two developments. First, last evening, the Senate voted to begin the process for ending the shutdown and funding the government, including full funding for SNAP through the end of the fiscal year. That proposal, if adopted by both houses of Congress and signed by the president, would end the shutdown and moot this application, meaning we won't need the appeal. But we still need it because we don't know what's going to happen in the next 48 hours to 72 hours in Congress. Do you? Second, this morning, a district court, that's Judge Talwani, who I just read from, in a related case issued a temporary restraining order. The TRO directs the states that had processed that TRO purports to stay. Doesn't purport to stay, it stays. The USDA's November 8th memo that directed states that had processed full payments to undo those actions and revert to processing 65% SNAP payments for November. That's again, Ketanji Brown Jackson forcing the Trump administration to beg the full Supreme Court for permission to starve people. I'm Michael Popok. I'm glad you're here on MeidasTouch Network and Legal AF. You can see this is a fast-moving story. I'll cover it here on Meidas. I'll cover it on Legal AF YouTube and on Legal AF Substack. We're getting close to our 1 million threshold subscriber base on Legal AF YouTube. Come join us there. And on Legal AF Substack, join us there as well and consider becoming a paid member. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.